Lesson: Overview of consumer rights under federal and state laws. Understanding consumer rights under federal and state laws is a critical aspect of privacy protection and compliance, especially for professionals seeking certification as certified information privacy professionals. The landscape of consumer rights is shaped by a complex interplay between federal and state regulations, each offering varying degrees of protection and enforcement mechanisms. This lesson aims to provide a comprehensive overview of these rights, equipping privacy professionals with actionable insights, practical tools, frameworks, and step-by-step applications that can be directly implemented to navigate real-world challenges effectively. At the federal level, consumer rights are primarily governed by legislation such as the Federal Trade Commission Act, the Fair Credit Reporting Act, and the Health Insurance Portability and Accountability Act, among others. The FTCA, enforced by the Federal Trade Commission, prohibits unfair or deceptive acts or practices in commerce. This broad mandate empowers the FTC to address various consumer protection issues, including privacy and data security. For instance, the FTC has brought enforcement actions against companies that fail to adequately protect consumer data or that misrepresent their privacy practices. Privacy professionals can leverage this regulatory framework by conducting regular audits of company policies and procedures to ensure compliance with FTC guidelines and mitigate risks of enforcement actions. The FCRA provides another layer of protection by regulating how consumer credit information is collected, disseminated, and used. It grants consumers the right to access their credit reports, dispute inaccuracies, and be notified of adverse actions taken based on credit information. A practical tool for privacy professionals is implementing a robust data subject access request process. This process should include clear procedures for verifying the identity of requesters, timely responses within the statutory period, and comprehensive record-keeping to demonstrate compliance with FCRA requirements. In the healthcare sector, HIPAA sets the standard for protecting sensitive patient information. It establishes national standards for electronic healthcare transactions and requires organizations to implement administrative, physical, and technical safeguards to ensure the confidentiality, integrity, and security of electronic protected health information. Privacy professionals can utilize frameworks such as the HIPAA Security Rule Checklist, which provides a step-by-step approach to assessing compliance with HIPAA's security standards. This checklist includes evaluating risk management processes, access controls, and encryption protocols, thereby enhancing an organization's ability to protect patient data effectively. State laws further augment consumer rights by introducing additional protections and varying enforcement mechanisms. For example, the California Consumer Privacy Act grants California residents specific rights regarding their personal information, including the right to know what data is being collected, the right to delete personal information, and the right to opt out of the sale of their data. The CCPA also imposes stringent requirements on businesses to disclose their data collection practices and implement measures to protect consumer data. Privacy professionals can implement a CCPA compliance program by conducting data mapping exercises to identify the types of personal information collected, the purposes of collection, and the third parties with whom data is shared. Additionally, developing a consumer-facing privacy policy that clearly articulates these practices can enhance transparency and build consumer trust. Other states, such as Virginia and Colorado, have enacted comprehensive data protection laws that mirror the CCPA but introduce unique provisions. For instance, the Virginia Consumer Data Protection Act and the Colorado Privacy Act both emphasize consumer rights such as data access, correction, deletion, and opt-out options for targeted advertising. However, they also introduce differences, such as the VCDPA's distinction between controllers and processors and the CPA's requirement for data protection assessments. Privacy professionals must stay informed about these state-specific nuances and adapt their compliance strategies accordingly. One approach is to develop a state law comparison matrix that highlights key differences and similarities across various state privacy laws, facilitating a tailored compliance approach for each jurisdiction. To illustrate the practical application of these principles, consider the case study of a technology company that faced scrutiny for its data collection practices. The company, operating across multiple states, was subject to both federal and state privacy laws. By conducting a comprehensive privacy impact assessment, the company identified gaps in its data handling processes and implemented corrective measures to align with legal requirements. This included enhancing transparency through updated privacy notices, implementing robust data security measures, and establishing a responsive DSAR process. As a result, the company not only achieved compliance, but also fostered consumer trust and loyalty, demonstrating the tangible benefits of proactive privacy management. Moreover, statistics highlight the growing importance of consumer rights in the digital age. According to a Pew Research Center survey, 81% of Americans feel they have little or no control over the data that companies collect about them. This sentiment underscores the need for privacy professionals to champion consumer rights by advocating for transparent data practices and robust privacy protections. By integrating consumer feedback mechanisms, such as surveys and focus groups, into privacy programs, organizations can gain valuable insights into consumer expectations and enhance their privacy practices accordingly. In conclusion, understanding and upholding consumer rights under federal and state laws is paramount for privacy professionals. By leveraging actionable insights, practical tools, frameworks, and step-by-step applications, professionals can effectively navigate the complexities of privacy regulation and enhance their proficiency in this critical area. Whether through compliance with federal mandates such as the FTCA, FCRA, and HIPAA, or adapting to state-specific requirements like the CCPA, VCDPA, and CPA, privacy professionals play a crucial role in safeguarding consumer rights and fostering trust in the digital ecosystem. Through continuous education, proactive risk management, and consumer engagement, privacy professionals can not only achieve compliance, but also contribute to a more equitable and transparent data landscape.